Hey there, Greg Siskin, and I'm kind of laughing because I'm the only one that's here, and I am not from Cook Baxter. I'm from Siskin Susser, but we work together on our litigation matters. So I'm here on behalf of IMMpact today. You don't get the rest of the team, but hopefully I'll be able to update you guys. It's actually again, unfortunately, not an eventful week as far as news on any of our cases, but I'm going to give you the quick update. I know there were a couple of questions. I'll try and address them. Hopefully, I will be able to. If there's some, I have. It's nice when there's a couple of us here because not every one of us is working on the case. And I've actually been spending a lot of my energy on the H-1B case on behalf of IMMpact. So. I'll talk about that one as well as the ban cases that are pending. So, also, since Chuck is usually the one driving here, I don't know where his captions are for the different cases. So I am just going to tell you the cases by court and subject and names. We have the 239 country ban cases, which I know a lot of you are paying close attention to. They're not, well, we have 339 country ban cases. One is suing the State Department over visas. The other two are suing USCIS over the benefits pauses. We have a Georgia case and we have the Colorado case. Georgia is, and I apologize, Neza Meslami, and then Colorado is Ahmadi. The question has already been asked in about whether we. I think this was. When do you think we'll receive a PI in the Georgia case? Do you think the judge will set deadlines for adjudicating 765s or risk losing your jobs? Yeah, it's very frustrating. I know how long it's taking, and it's definitely taking more time than what we usually see in these cases. That is not a. I would not read anything one way or the other about one way or the other, whether that's good news or bad news. The fact that the judge is taking a long time. Sometimes it's a good news because the judge is really, wants to be careful about when they defy what the administration is doing. They want to be very meticulous in explaining why they're ruling the way they're ruling. Sometimes judges are paying attention to what's happening in other courts, and they are waiting. They're looking at them, and I think if you're online, you know that there's a couple. I think there's a couple dozen of these cases that are. Some of them are for bigger groups, some of them are for individuals that are pending around the country. Good news is they all seem to be going in the same direction, which is a preliminary injunction. Not always getting the same relief. So I'll talk about what's happening to 75 country ban case in a minute. But that being said, we don't know. There is the news that I can tell you this week. So any of, obviously we're always affected by what's happening in DC. One of the things that shouldn't be impacting us, but is impacting us, is this gunman at the White House Correspondents' Dinner who was not an immigrant, didn't and should not have any impact on this, but it's a convenient excuse for USCIS to. Hold on a second. Zach New, glad you're joining me. I'm trying to explain sort of like what this new shadow ban on adjudications is. You probably could hear me for a second, but what I was saying is that we were talking about the Georgia case, and that we still don't have a decision, and the people are getting worried as they should be about their 765s expiring, and we can't basically go knock on the judge's door and say, hey, do your job, unless you want them to do their job and give us a bad decision. But what we can do from time to time is if there is news, if there's news that's happening at the agencies or news from another court, we can basically file something to let the judge have that information. And that is what I was just about to get to with respect to this latest thing with the White House Correspondents' Dinner, which has led to new benefits pauses. CBS News and CNN and probably others have been reporting that there is a memo, an internal memo that hasn't been released, and I've been working reporters that I know today trying to get it, and they're all basically promised that they're not, their sources, that they're not releasing it. It's probably all the same person. So we don't have it, but what we do have is we have those news reports, and we have AILA's advisory on that. So the question I have for you is, we're going to be notifying the judge for two purposes. One, because it's newsworthy and it's important to this case. And two, to let the judge know that we're watching this case and we haven't gone off and forgotten about it. So where are we on that notification?
Yeah, so I guess let me also just kind of give a brief where we're at with the motion to dismiss briefing, because that's also playing into this a bit. So the government, for those who aren't kind of keeping track on filing dates, March 30th filed motion to dismiss the case. That's not anything unusual or bad or anything along those lines. It's kind of a typical practice. We responded April 13th. They replied as their dates were permitting to on April 27th. That's like the last date that they could. There were some new arguments in there though. So you always get a chance to respond to arguments that are presented in a lawsuit, and where new arguments are brought up in a reply where we don't have a final, like we don't have a response to a reply, you can request this thing called a SIR reply saying, hey, new stuff came up, give me an opportunity to respond to that. So that's what we're doing. We're going to file that today. And I wanted to make sure that we had that in before we filed notification about this. And then there's also another PI that was granted that I'm going to submit another supplemental authority request on. And the reason being there is, as Greg was saying, this is kind of poking the judge saying, hey, remember this case? Remember this? And I wanted to make sure that our final arguments on the case were in before we started being like, make that decision right now. Wanted to have our final points there first. So that'll be in today after we've gotten the SIR reply request filed as well. Just we don't want to have stuff.
We're getting and there's a question here, but it sort of is coming up in these cases is the actual orders that are coming from the judges in the preliminary injunction. So I think in one of Curtis's cases, he won, but there was no deadline that was imposed by the judge to order. And I know that we had a question just now about that in the Georgia case. So that's something that the judge has a lot of control. The judge has all the control over that as far as the scope, basically shaping the relief. But can you talk for a minute about what we've been seeing on these cases and maybe what's reasonable to expect?
So I have certainly not kept track of every single what happened after every single PI. I know that the two earliest ones, we had an I-45 based PI, and they got interviews very, very shortly after the PI was granted. We had an I-765, and that I-765 was issued very, very shortly after the PI was issued. I believe the McBean case got a stay as they were briefing the temporary restraining order. And from what people have told me, there's not been a lot of action from USCIS on that. And that's something that I imagine the McBean team will bring up directly with the judge to say, hey, you stayed this action. Why are none of my plaintiffs getting any sort of action taken on their case? Why don't we have any decisions?
Right.
And then I'm not sure about Curtis's most recent case, if those folks are starting to get decisions. But that's what I would expect, is that we'll start to see decisions be made. And one thing that we kind of have that some of these other cases maybe don't have is the benefit of a mixed group. So we have I-765s for folks with OPT. We have H-1B extensions. Those have premium processing associated with them. So we would expect that happens pretty immediately. And where it doesn't, then we can really point to, like, there was an explicit statute or regulatory deadline here. This plaintiff paid $3,000 for this deadline to be met. None of these are happening. Judge, what's going on? So I think Jesse brought up a few lives ago that we would be requesting status reports, and that's very much why, so that we can say, here's the number of plaintiffs that we have, here is the relief that the plaintiff is seeking, here's how long they've been waiting since you made your order. Like, what's, of the 7,000 plaintiffs, not that there's that many, we've had 4 who've had final decisions. What's going on there? Clearly, USCIS is not complying with your order in good faith. So we can come back to the judge and come back to the U.S. attorney first, but eventually the judge with that.
Yeah, I mean, I think that's the right point, which is that the judges are monitoring this. So I'm getting an echo on myself, but that's everything that's moving in these cases, and we're obviously tracking every single plaintiff. We will be reporting to the judge, but we also are in close communications with the government lawyer as well, because sometimes they're not actually closely informed about what's happening on their cases. So we've traditionally in our cases in the past have a dashboard that we have that's pulling data automatically, and we see sort of a live spreadsheet every day of what's happening on these cases. So that's what will happen. So let's keep it moving and talk about the Colorado the Colorado case, which has been filed, but it was more recent. So where are we in the briefings on that?
Yeah, so the PI was filed on early last week, 20th, 21st, filed that day. So a lot of the Colorado stuff has a lot of local rules associated with it that the Georgia case doesn't, that causes a little bit of delay. So like the preliminary injunction, can't just file that. You first have to talk to the government attorneys and confer and see if we're able to limit the issues, or if they're willing to just grant the relief. Not that they would do that. So it's kind of a waste of time, but you have to do that. So that was what we did, conferred with them, said, hey, we're not able to do anything yet, and then filed the preliminary injunction. So they've got 21 days from that to make their response to the preliminary injunction motion. And then we have 14 days to reply there. I don't think we'll take all 14 days. It'll be, I think, a lot faster. And then if the judge wants a hearing, we'll have a hearing. My expectation is that the judge will not want a hearing, because we have now gone, it'll be 5.5 months, almost 6 months then from the first pause being put into place. We'll have dozens of other courts having granted the preliminary injunctions. I think that the weight of everything will really push the judge to just make a decision fast without saying, all right, we'll have a hearing in a month, guys, because I want to hear more about the issues. That's especially true if we get the judge that I think we're going to get, because they're senior status and they prefer to just rule on the papers. So that's my expectation. We'll get a decision fairly quickly without a hearing, although of course the judge can order a hearing if they want to.
Okay, we just addressed this question about the Georgia case in the reply brief, so we can move on from that. This was this is a question regarding whether we think it matters that the case is a collection of a lot of different types of benefits, or it makes a difference if they're all one category or another. And the legal theory is not any different. If you for an I-765 versus a naturalization case, I mean, they're obviously very, very different types of benefits that are being received, but the violation of the law is basically all the legal arguments are essentially the same. So it shouldn't matter. It's more complicated on our end as far as putting the case together, because we're describing a bigger variety of harms and situations that people are in. But as far as the legal arguments go, it's going to look pretty similar. What we're going to be arguing, whether it's a mix or all the same. Would you agree with that?
Yeah, and I'm getting this question a lot, folks saying, hey, 765 seems to be going the fastest. Is it a harm to us because we aren't focusing on 765s, for example? What I think a big issue is that people are looking at a pretty limited data set. And we have some very highly public cases. We have things, there's a bunch of cases that are being tracked by some plaintiffs in the pause tracker. That's not catching every case, though. I saw one last weekend. It was an E2, preliminary injunction for an E2, and that was granted in a month. That's very, very different from a 765, and that was, I think, the fastest one that I've seen so far. So you're not getting all the data points because not everybody's just publicly saying, here is one more individual case on the pause. It's very easy to see the big ones and say, if I was in that one. But there's also a lot of other ones that have been filed that are going slowly, that are or going fast, that are different types of benefits. So it's not dependent on the benefit as much as I think it is on the judges really wanting to get it right. These big cases, the judges have some exposure for appeals potentially, and they don't want to have a court of appeals overturn their decision. So I think that they're really, really working to get the right decision. And in our case, if I was to guess the Georgia case, why that's taking a longer period of time, it's just kind of like the coincidental timeline of everything happening. The April 1st guidance is what the judge really wanted to make that decision on the PI. And it just so happened that was when the government's motion to dismiss was due. So if the judge had any questions about any legal part of the case, well, now he has the benefit of the motion to dismiss, the response, the reply, our SIR reply. So he gets the chance to get a little bit more information before he makes the decision. So that's my guess. I can't say for sure. He could also have a bunch of very big jury trials going on. And
that's the thing. You can't know what's. There could be a million reasons why the judge is taking a while. And you can't read the tea leaves and say it's taking longer. That means he's more likely or less likely to give us what we want because we're not mind readers. The 39 country visa ban case that we have in Boston. Do we have any? There's no news on that case, but that's all briefed, right?
No big news there. It's a lot of just. Of working with the government attorney to get the schedule worked out, to push for expedited summary judgment. We're not going for a preliminary injunction there because we want the final relief. No major updates besides things are kind of moving forward.
Okay. And the last of the 39 country cases is just the one that we're onboarding right now. So if you, and I guess it's just, we have a couple more days before that onboarding closes. So if you're in that situation and you want to be in our litigation, you need to move relatively quickly. We have been having discussions amongst the lawyers about where we're going to file, and that depends on, to some extent, where our plaintiffs are. But we don't have that news yet. But and we usually don't make that decision until very close to the end. So that's the last of 39 country cases that I think we have to talk about. We have the Masood case, the 75 country ban case that is in DC. And that's one where we just had some news on Curtis's case, I guess, on there, which was good news. And it's the same court, I think, too, right?
Yep. Not the same judge, but same court. But yeah, not the same judge.
Yeah, which is always, yes, the two different judges in the same district court can reach two different conclusions, but it is helpful when we have one that's just reached a decision going one way. That doesn't mean you're going to get the same result, but that certainly was good news. Can't read it. You can't read that any other way than it being good news.
Absolutely. And for those not kind of familiar with the strategy there, kind of going for vacatur entirely of this pause. Some other, I guess, background news is there's been in the regulatory agenda for this administration like a new form for bonds and for things like that for getting visas issued. It's moving towards its kind of final form. It takes a long time for things to go through the regulatory process. I don't think that this is going to be something that happens like tomorrow or next month even, but we would get at some point, possibly like end of the year, early next year, this new form that comes out, and that might be what the government's waiting on to internally lift the pause if one of our lawsuits. The clinic case here referenced our lawsuit, one of the DV cases that's also challenging the 75 country ban. Like, if one of these doesn't get rid of it, the government might, at the end of the year or something along those lines, have a new process that they put in place to lift it.
Yeah, and that's always a trap question when somebody asks us when we're going to be getting. First of all, it makes the assumption we are definitely getting summary judgment. And if that were the case, we wouldn't actually need litigation to do anything if it was sort of an automatic that we were getting anything. But assuming that we get something favorable, it's also foolhardy for us to make those predictions on when it's going to be coming, because no matter what we predict, we'll probably be off either earlier or later. So you can ask the questions, but we're going to give you the same responses every time, which is like, hopefully soon. That's basically our go-to answer. Okay. Anything else on the 75 country case?
I believe the clinic case is going very well. Those lawyers are tremendous lawyers, and I, from the briefing that I've seen, it's going very well. That's as much as I've got. And the other ones, I guess, is that the DV cases that we probably are going to next. Yep, those are also challenging the 75 country pauses. So that's in the background here.
Yeah, so that case is the DV case is also in DC, and we are, we hopefully I think that is that with the other cases that are not filed by us but others. I think on this, are we the only one on this issue that's litigating, or is there others? Because I'm not sure. I remember when we were discussing the 75 country ban and raising that, that was there were some strategy questions regarding whether that was going to slow down the case or complicate it or on there. But we ended up making those arguments. So that to some extent it's a little bit more complicated the what we're asking for than before. So whether that's going to affect the timing, I think that's speculative. But that anyway. What do we expect the government attorney to present on Friday?
I believe that's their reply is due, so probably nothing all that worrisome. It's going to kind of be rehashing the same arguments they've made as to the motion for summary judgment, all that stuff. So the judge put us on a really, really expedited timeline for everything. It's all good. This just means that we all have to rush to get our arguments in, and that's they're going to have their final points. I don't expect anything, groundbreaking.
So this question regarding this new this secret ban or pause on here, because it's not actually published, but there have been news reports and American Immigration Lawyers Association sent out an alert, so we know it's real, and you all know it's real as well. You wouldn't be asking the questions. So if you weren't here earlier, we are briefing. We are going to get that information to our judges. If we actually get our hands on the memo, great. Right now, it's not officially out there, and I checked with some reporters who are telling me that they can't that they're not permitted from. Well, they made deals with their sources to get this stuff and not actually publish it, but we can certainly present the news stories and the information that we have, and I'm pretty sure that a judge will be just fine with that. But if we actually get the document, we will present that too. Okay, so the DV consular case we talked about, I think, and then the last one I had on this list before the H-1B case is Does v. Rubio, which is the Sivas case. And that's the visa ban case, and that's another one that is we're just kind of in a holding pattern, waiting for the court on that. Is there anything to report on that one?
Nothing there. It's I know a long saga for this. It was beginning of April last year is when the first CIVAS bans were happening. So we're over a year in for these folks. It's been a long haul.
Okay. On the H-1B case, if I don't know if there's any folks that are interested in that one, but that's also a one that we've been waiting a long, long time since I think that one was March 8th or our arguments, and it was the 18th. I think was the Georgia case. The 8th of March was the Global Nurse Force H-1B case, where the arguments were made. And that's one that we are having the all lawyers calls. We're co-counsel with Democracy Forward and Justice Action Center and a big class action firm on challenging that. And we have a call every Tuesday where we basically, since March 8th, it's like, when do we think the judge is going to issue that decision? And we're still at this point, it's the same thing in that case where, like, for example, we know that the national interest exceptions have all been denied since the arguments were made. So we did a briefing on when those were coming in with some declarations from people that got NIE denials. So it's the same thing where we're just trying to, like, nudge the judge gently, recognizing the fact that they are the judge and have all the power, and just let them know that a lot of people are really needing this relief. And here's some information that might be news since the arguments that might be relevant in making that decision. But that's where we are in that case. And we have we're in that case, there's two other cases that are going on right now. One is the state attorney's general case on the H-1B $100,000 fee in Boston. And that one, they were not asking for a preliminary injunction. And that is, I believe, fully briefed now. But there's no news in that case. The other was the Chamber of Commerce case in DC. The Chamber had their arguments for they lost at the district court level, Judge Howe. In the DC circuit, they've had their arguments. I believe they were a few days before the arguments in our case. So it's either late February, early March for the DC court. And again, nothing coming out of the DC Court of Appeals on it. And we think it could be the case, like like what we were talking about before with the Georgia case, that sometimes the judges are delaying because they're wanting to see other cases and what's happening. And that very well is possible in the H-1B case, where our judge wants to see what the DC Court of Appeals is going to say about this before he makes a decision. So again, that's the theme of the day: is we file and we argue and we wait, and we keep our fingers crossed. So that's I think that is, Zach. That's the last of the update. So we can kind of like hit these questions, and I'll just start posting them one at a time. And some of them are like super fact specific, and we'll just tell you that here, unless Zach, you think anything that we can add that in a general way that you'd want to say, or do you want to say that's too fact specific? Talk to your lawyer.
I think that one is talk to a lawyer. I would say that that's a long time for advance parole, but not necessarily. I mean, yeah, talk to a lawyer. That is a long time for advance parole, so maybe.
All right. We talked about the DV pause, sent mails as instead. All right. That's the update, is that what we just gave you, which is that it's all briefed and we're just in waiting mode. Okay.
Yep.
Okay. So this is sort of a question about, and there was another question somebody asked about. Actually, let me go back to this other question because it was similar to this one. But this was somebody: I'm part of your case. Can I also file my own lawsuit? So the answer to that is you can't litigate the same issue in two different cases. You have to pick one or the other. And if we find out that you filed your own individual lawsuit, then we have to file a motion to dismiss you from our case. But is there The other question was sort of just about making a decision on whether to go with a group or an individual lawsuit.
So I will add to that though, you can have two cases going that are not covering the same issue. So you couldn't have two cases on the pause, for example, but
Right.
we don't have like a mandamus component to ours. I don't think it makes sense to file a mandamus right now, but you could file a separate mandamus that does not talk about the pause, just saying it's taking a really long time,
Fair enough.
and that's okay.
Okay. This is a question sort of, we get this question a lot about whether it's better, what the advantages and disadvantages are for going individual or going for a group. Um, and so let's talk about it sort of at the high level regarding whether you should, obviously there's a financial question, which is it's usually a lot more manageable. To do it that way. And for a lot of people as well, they don't have, it's not just the lower cost, but it's maybe less aggravation when you are joining a group case where you don't have to be as participatory as you would be if you were just suing on your own with the lawyer who's there's a certain amount of time that your individual lawyer is going to need from you to do that. So that's a factor sometimes in these cases. On the other hand, when you are the only client in one of these cases, you have a lot more of a say over the strategy. Sometimes you live in a jurisdiction that is not the best, and being in a group might mean you're filing in a more favorable court. What are some other differences that you would think would play a role in whether you decide to go one route or the other?
I think the big one is that in a group, you are one of many. So even if you have particular facts that you think are tremendous, that are going to be like, a really, really powerful way of pushing the case forward, you can't do that. Like in the group 39 country pause case, we couldn't say, hey, remember all those doctors who are not able to get placement for residency? Because as soon as we start to push one particular narrative forward, then the case would be severed. They would say, okay, well, this is not common issues of fact anymore. Clearly, we're having very different groups that are suing about this in one big action, and we're going to have to sever them into their kind of constituent parts. So you get the benefit of potentially better location, about cost, about time intensiveness as well. But you are a part of a group, and you have to kind of remember that you are one of many. And in some ways, we can't push certain legal theories as well because of that. So, like in our 39 country ban case, we aren't doing the mandamus component to it because that opens us up to a lot of vulnerabilities in the case where individual factual circumstances come out. So by being a part of a group, that legal avenue is cut off. So it gives you certain benefits in the sense of, really resources and venue, I think, are probably the biggest ones. But there are certainly advantages to individual cases as well. I don't think that there's always anecdotal evidence of big case versus small case as far as speed goes. I don't think that there's actual evidence of that being the case, but it's anecdotally people think that the smaller cases go faster.
Yeah, there's you'll hear both sides of it. It's like whether they're more likely to settle with the big case or more likely to move more quickly on a case where there's just one person. Or you a lot of times you're trying to game out which strategy is going to work, and it very much you don't know because it depends on the personalities on the other side, which are going to be different in every case. If we are always going up against the exact same legal team and same agency, we might be able to be able to predict a little bit better, but that's not going to be the case. I only wanted to push this question because we've addressed some of this before, but about the last part on here about contempt of court. Contempt of court with this administration, they blow past what's reasonable, what the red lines would be all the time, and it seems like the judges, no matter where they are on the spectrum, give them a lot of latitude, more latitude than we would have ever probably have believed in the past. But so I would say don't get your hopes up regarding if we win on the about getting contempt of court. The judges do have a lot of ways that they can make their position clear to the government lawyers. Contempt of court is usually. I mean, you could correct me if I'm about this act, but I have not seen very many. I mean, there have been a lot of ones where it's like, surely this is going to be the case where this judge is going to issue a contempt of court ruling, and then it was like, nope, they let them go, give them one more chance, and then and then usually the government ends up complying with that by that point.
He actually got a magistrate judge to say, yeah, the judge or the government violated the PI. You should hold them in contempt. This is one of the issues with magistrates. They have to make recommendations to the district court for major motions. So we won with the magistrate. We're like, absolutely, we're going to get our clients what they need. We're going to get, they're going to get paid for the fact that the government is not complying. And then the district court said, actually, no, I'm not going to do that. But to Greg's point about like, there are other ways of making the agency comply. I've seen orders where they're like, I need the head of ICE to come into my courtroom tomorrow and tell me why they aren't, your local office isn't complying with me. And
that's effective.
Yeah. Head of ICE isn't flying down to Minnesota to get into a court hearing. So yeah, there are ways, even if it's not necessarily contempt of court.
All right. This question, I'm not sure what they're asking.
I think they're not doing a ton of removal defense to know for sure. And I think it's also a little bit jurisdiction specific. For some places, a matter of QLE, a matter of, say it wrong every time. You know what I'm saying. Are still in effect, but in others they're not. It really depends on your particular jurisdiction. I think you got to talk to your lawyer.
Okay. So this was a sort of an interesting question regarding the 75 country ban case, regarding these visa bonds that are sort of a new thing. I mean, they've been around for a million years, but life has been breathed into this by this administration. And this person sent in the bond payment. We haven't heard any. I don't think we've heard anything about that affecting the individuals that are subject to it at this point. But it is an interesting question because, in theory, that should make it easier for them to, if they're going to make exceptions, that would be one factor. Presumably, that would go in is that if the person has demonstrated their financial, that they're not. I mean, this is all, the 75 country pause is all about public charge. So in theory, this addresses that, but I haven't heard anything on this.
This is what I was talking about earlier. This is also, I don't think it's going to be an immediate solution because they kind of didn't comply with the OMB procedures. So the OMB was like, no, that's not sufficient. And then they were like, okay, well, whatever.
This is the second part of that question. I mean, it's the end of it, but.
Oh, yeah, I don't think that they'll use it as a legal maneuver. I think that if anything, this is maybe their end game with this is to try to get a pretty expansive bond policy procedure in place. But I don't think that we're seeing it in like May, June. I think that because they're doing this in such a kind of haphazard way, it's going to be a while before we see an actual new I-945 come out, if anything.
All right, so this is one I actually have I'm poised to answer on here. So in a J1 case, there's two parts to it. There's the part with the State Department issuing the 212E recommendation. That's the DOS part, and then the I-612 application is usually decided shortly thereafter by USCIS, and it's just a sort of a routine thing. But USCIS is I believe that they are sitting on the 612 applications as well. So the answer should be yes. I would say if you're at the point where you are waiting on the waiver review office to issue the waiver recommendation, that's not going to qualify because it's not that you're not affected by the pause for that part of your process. you are affected after state sends the recommendation to USCIS, and then you're waiting on that 612 approval notice, which you need as well with the now, and also you can file for the H-1B at the point where State Department has filed. So you may actually have an I-129 pending as well, and not just the 612 that you're waiting on with USCIS. So the answer is yes for both of those benefits: the 612, the waiver application, as well as the I-129 for the H-1B. Any disagreement with that, Zach?
I've been hearing 612s are a pause as well, so
Yeah, I think so. Okay. I'm looking, we talked about, somebody asked a question about 39 country ban. I'm going to skip that one because we talked about that. Somebody's asking about the DV, how confident we are. We're always sort of cautious. we're always cautious, but we don't file these suits if we don't think we have if we don't have a good claim. And generally speaking, on all of these pause and ban cases, the courts have been giving pretty, they're pretty favorable decisions for the plaintiffs. So I don't think we can say more than that. Okay, I'm looking for a next question. The PI is granted, we file a new application. How is it handled? Does it? So this is a question we've gotten before. So like about subsequent applications after you benefit in this on one, and then it's sort of followed by the next and the the next part and the next part and the next part that you would be filing. So the you should be the pause should be off for you for the next parts as well.
it will, though, depend on the specific language from the judge's order. So, like, that's what we've asked for. But if the judge limits it to only pending applications, then it's only pending applications. And then that's where we're also looking for the permanent injunction. That's why the PI itself is not the end of the game.
Yeah. Okay. Is there any way you can emphasize the PI order from the Baden's case where the judge sets a few deadlines to monitor the part? So this is the new decision. That's this is Curtis's, right?
Yeah, that was last Friday, I think.
Yeah. Yeah, so we definitely like alert the judge. It's the same court though, so they usually know. I mean, same. Or no, not on. That's no. That's for the 75 countries.
It's not Georgia, but it's. But we have already alerted the judge to all this, and I swear that's all I do every day is send in new alerts to the judge of, hey, here's this case saying these things.
It's your newsletter.
You want to make a decision test for us?
So this is one, it's not about our cases, and actually I'm going to be talking about this on our firm's live stream tonight, but what do we think about this? We got there were hard questions that were asked by the judges that you expect to ask hard questions of the government, and then there were softball questions by the judges that you expect. This is going to be decided by the three justices in the middle. It's my prediction. The four justices in the middle. Two, we know how they're going to go. Three that we know how they're going to go. The three liberals are going to go one way. I think it's interesting though. Some of the arguments sort of. Again, I mean, hopefully the plaintiffs made the case with TPS. Just, the idea on TPS is it's very easy for a president to act quickly to grant TPS, and they have a lot of discretion in doing that. The assumption that the Solicitor General, at least from the quotes that I saw in the news media today, and I wish I would have had time to listen to the actual live arguments, but we're indicating that basically that the statute itself gives the president this very broad and quick authority to get rid of it and not get rid of it. And I think that the plaintiffs conceded, as they should have, that the president has the ability to get rid of it, but it's supposed to follow procedures. And at a minimum, the president has to at least have findings showing that the conditions that led to TPS in the first place no longer exist. And I think that that's largely why the judges have been ruling against the government is they haven't made any findings. They're just saying we're ending this program on a certain date and not explaining themselves, and that's the issue. And so I think it's largely the court has to make a decision on, and they could take the same approach that they took with the Muslim bans, where eventually they said the president, yes, the president can impose this ban, but you have to actually, there's some diligence involved, and you have to actually provide the reasons why you're doing it. We don't just assume that that it's in the best interest of the country that you do that. So it could be that that's where they come out on it, is saying, that, and I think that's probably where it will be, which is that it's not going to be just a straight win saying that the administration can just get rid of it without any reason being provided. But I have a feeling they're going to get a lot of latitude as far as what reasons that they can give. That's my prediction, is that it will be like that voting rights case that came out today, where they didn't say that the Voting Rights Act is dead, but they kind of changed the standards, and we don't really have any standards that have ever been enunciated as far as why TPS can be taken away, and that might be what comes out of this decision. So, got a different take?
Well, I think it's going to be an interesting kind of balance between the politics and the law. We have the conservative justices are all about the what does the statute say. So I think that it's not so clear cut that it's going to be like 7 or 6-3 or something like that.
Yeah. All right. So you mentioned before that we don't have a judge yet.
We have a magistrate, but we don't have a district court judge because we need to have a government attorney enter their appearance. We got to do the magistrate consent form. All the stuff in Colorado is the kind of procedural, non-fun stuff happening right now. The PI has been filed, and we're waiting on the response there. That's kind of like the big substantive thing. And then in the meantime, you're going to see like, the service has happened against USCIS, and the magistrate consent form has been filed, and this person entered their appearance. So nothing really exciting happening at the outset now that we filed the PI.
Okay. All right. So what say you on this part about the 30-day?
Super common, especially in DC. It's kind of like a rule that on day 59 they say, "Can I have 30 more days?" And the judges say yes. Like for the student DOE cases, the government got first, what was it, like a 60-day and then a 120-day extension on their complaint because they're like, we've got too much work to do. So it's super common. It doesn't really mean anything. Besides that, the District of Columbia is extremely overworked and understaffed.
Okay. This is a question, speaking of students, whether there is any signs that DHS might take over I-20 extensions or related adjustments instead of a DSO. I have not heard that. And it seems like that would require a lot of regulatory changes that would not happen very quickly. Are we challenging the negative country factor? Yes, we made that argument about the discrimination. Okay. Another one asking for the odds on there. Maybe we should go on Kalshi and start gaming the odds on these pieces.
Saying this it was maybe a plaintiff specific call, but I don't think that, especially in Colorado, one of the big things I like about Colorado is it's not really liberal conservative. Even like the very conservative justices are like super libertarian, so they're really against executive overreach. We had, I don't know if anybody knows what an ICE detainer is, but ICE sometimes would say to a local jail, "Hey, keep this person in jail for a little bit longer because we're going to come by and pick them up." And in Colorado, we were able to really make the argument, not like me specifically, but like the immigration attorney community in Colorado was able to make the arguments to the judges, like, look at this horrible overreach from the federal government jumping into your local jails to force Fourth Amendment violations. And the judges were like, yeah, no way, not having that. So it's not as easy as liberal judge versus conservative judge. Judges they're smart people, and they all have nuances to that.
You never know who you never know who you're going to get. Even in Tennessee, which is the reddest of red states, there's a couple of judges that are definitely in a different world than the administration. All right, so here's a question about 39 countries and fiancés. Were there updates for fiancé visa for the? Oh, so this is the visa part of that case. So do we have?
If we're talking about the Chikumba 39 country ban case, if we're talking about that part of things, I mean, the updates are just we're we're moving forward. This isn't it's not a fast process because we're not going for a PI or a temporary restraining order or anything like that. We talked about it a little bit earlier today, but the updates are just things are moving forward. They're kind of plodding along like things do in the District of Columbia. If it's about whether there's like going to be exemptions for K1 fiancés for travel ban countries, I don't see it right now. It seems like it's going to be very long lasting, these bans, and there are not going to be a lot of exceptions.
All right, so this is about this new policy, and we know that it affects adjustment applicants, asylum applicants. Was there anything that you've seen in the news about DACA being covered by this latest internal policy?
Yeah, so I read the highlights. I did not have time to go into it in detail. I know it's a big
I didn't see that. I mean, this is not actually pertaining to one of our cases, but it's I'm going to be cramming for this over the next hour for the 7 o'clock live stream that I'm doing, because that's obviously the breaking news, and I've been busy today with a lot of stuff that's work related. So the answer is I don't think so. But if I'm wrong about that, I have 1 hour after this to figure it out. Okay. It's the same question. There's another question here, but I'm not sure which case they're talking about. And
we are going for a PI in just about all the cases, except for the cases that we're going for a summary judgment kind of right off the bat. There's no case that we're just asking for a stay.
Right. Okay. So this is which cases? This is not one of this.
I think this is could you potentially do this?
Right.
And maybe you could file cases for DACA. I suppose. I think it's risky. We decided against doing it. We didn't want to kind of rock the boat and cause any major problems for DACA as a whole.
Okay.
We couldn't do anything with the case that is in front of Judge Hannon. I mean, he's going to have that for the rest of his life, it seems like. If you're asking if we could file something with him, no way.
All right. So this is somebody who has a interview in Montreal. I'm guessing this is all right. So Canadians, dual citizens, and for the visa ban cases, are they? I thought the dual citizens are only being negatively treated in the visa, the pause cases, not the external cases. So the 221G, this shouldn't really have anything to do with the proclamations or executive orders, correct?
It's just that Iranians have always gotten absurd levels of vetting. That's just kind of the reality, but they are exempt from the travel ban, the specific proclamations barring entry. So that means the visa issuance should not be impacted by it as well.
Right. Okay. Do they want to cut it during the PhD? I'm not sure what this applies to. Okay. I think that is it. There was one nice, thank you. And then, I'm trying to. Oh, this was the. Oh, this is somebody who's in our suit. That asked that
Which,
question. This was the. This is presumably. Oh, this is the DV case.
okay.
Well, the DV case, that's a. I'm sorry, I missed that in the this question initially. Well, DV is based on at least the whether you're eligible for DV or not is based on the based on country of birth, typically, even if you're a dual citizen. But whether you're subject to the ban or not is not the same as whether you're eligible for the DV.
So the layers here, you're not banned from getting DV because you're Iranian, but DV is banned right now, and that's why we're suing about it. But assuming that's successful, you should be able to get your DV. That's the
Okay.
layers.
All right, got it. Okay. Yeah. So we had.
I got the. I think
Sign
I
it.
said that in a less.
All right.
Britt always says it in a better way.
Yeah. I think that's the last question. That is the last one. So it's 5:58. It is 4:58 your time. We did it. We kept it to an hour. We'll be back in a week. Hopefully, we will have something positive to tell you on these cases. Hopefully, nothing negative. And if you're, like I said, if you're looking to go into that last 39 country pause case, it's probably going to be the last one we do. Then you should probably get that wrapped up quickly. Otherwise, we'll be back next week. Thank you, Zach.
Thanks, everybody. Thanks, Greg.
Take it easy. Bye-bye.